everybody, we're on the air.
We're going to
Okay, we're in the last 26 minutes here. So, it's on. I don't know if it's working, but it's on.
It's working here.
Okay. All right, now, to recap here, the remedy is counterclaim. Okay? Now, a counterclaim is simply a lawsuit or an action at law. And you know what the first line says in your action at law. Okay? And so you basically sue and you're challenging the jurisdiction. You basically are saying, no matter how you fancy it up, basically all you're saying is, I don't see where your jurisdiction is. Show me your jurisdiction. What's your authority? They will then reply, our jurisdiction is code such and such or section such or whatever they say, and that's when you come back with, this is a court of record proceeding according to the common law. The statutes have no standing. That would be your reply. And then that's it. You cut off there, see? So you make your complaint, they answer, you reply to the answer. And now it's judgment time. Okay? You don't have a trial unless they ask for a jury trial. The trial is the paperwork in common law. Okay? Quickie on that one. Let me go to the procedure here. And we have action at law. I think this is the right one. Okay. Elements of common law action. Here's in a nutshell. You have the plaintiff makes his action, also called a complaint, also called a declaration. The defendant then demurs or he continues the pleading with his answer. Okay, then the third step is that you have the replication. All right. At that point, you have a forced joinder. That's a fancy way of saying, that's it, guys, no more papers. Now, under the old common law system, you could go continuously on, but you're supposed to narrow down the issues. Well, but in modern times, they say 3 papers are enough. I never argue that point. I'm happy with 3 papers because I get the last word in. Okay? All right. And then let's see. Here we go. One of the things we have on here is the common law causes of action. This is a quick summary of what they are. There are 11 causes of action that you can have under common law. 11 choices. You can have trespass, trespass on the case, trover, okay, ejectment, detinue, replevin, debt, covenant, account, and special assumpsit and indebitous assumpsit. This is all easy reading. I know these are strange words. We're not going to go into all these different words. The thing that usually you deal with is either trespass or trespass on the case. The others don't really apply. You're not usually collecting a debt from the IRS, okay? So you wouldn't use the action for debt and so on. So you can read through them. If you read them carefully, you can see it's really not all that complicated.
So the special assumption, Mr. Bill, you could sign that when they give you a ticket instead of signing your signature at the bottom.
Well, I'll tell you what, I don't remember what each of these mean. I always have to look them up each time. When I start a new suit, I read every one all the way through and get a reminder again exactly what it is, and then I decide.
Well, that's what it says. They shall be in your front.
Well, that's fine. That's okay. And the point is that you have the choices, and do like I do. don't be so smart you think you remember everything. Just go back and read it. It's short reading. There's only 11 of them, and they're not long, and it's very succinctly stated what each one is.
Cool.
Okay?
Very good, yeah. Cool.
Okay. Pardon?
That's great.
It was defendant under common law, underneath the plaintiff common law actions.
Well, yeah, you have defendants.
Okay,
Uh-huh.
Same one.
Sure. Yeah. A lot of the language is common to both styles. Okay. See what this says about caption. This is a typical caption for California, okay, and other jurisdictions. All right. Yeah, this is for normal action. And then further down, we have one here. This is an example of a counterclaim, how you would lay it out. Just showing the form is all. And then this one here, oh, this is a different format. This is how it's done in Florida. I put it there because I did a case in Florida one time. So that's that.
These formats will work whether we file LA, Orange County, San Diego, Superior Courts.
Oh yeah, within a state, it's uniform throughout the state. But you know, if you ever have any question about format, of course you can read the rules, but just go down to the court, pick any case, pull it out, and see how they laid it out. That's the easiest way. Let's see. This is a counterclaim for trespass and trespass on the case. That's one we looked at earlier. Okay? So it shows the layout again, which we already had seen that. And so then we have, let's see, first cause of action, trespass. Okay? Laid out in the usual format, mentioning court of record and all that. So the major elements, basically, here's what you got. You have the cause of action. You can have an introduction if you want. Remember, when you're writing these things, not only you're writing legally, but you're also writing for somebody who doesn't want to read. So you want to make it as easy to read and not get it too cumbersome and complex with too much detail. You only put in the detail necessary to prove the point, and that's good enough. Let's see. You have here we have the specifics. We had an introduction, then we had the specifics, and then we go down here, and I know we're going to get to it eventually. As we buzz down, here we go. I think I passed it. Oh, that's the second cause of action, trespass on the case. Third cause of action. Okay, and then the law of the case. Now in this case, rather than, the case was already cumbersome. It was getting thick. So to cut down on the basic paper, remember most of your courts, they have a rule that says no more than 15 pages. If you have to go more than 15 pages, you have to apply to the court for permission to have more pages. But what you can do is you can have exhibits. So you say, like here on paragraph 37, we said, Exhibit G is incorporated by reference as though fully stated herein. So here we had a whole bunch of pages more, but they're set off to one side.
Do you use the legal form, the 8.5 by 14, or
All
you
the
can use letter size?
All the courts are going to letter size.
Oh,
None of them really like it anymore. I don't know any courts that I've been in that want legal anymore. You know, standard filing cabinets are cheaper than legal filing cabinets. So I think, you know, they're driven by economics. Okay, and then after you put the law of the case in, you put in a request for relief. You have to tell the court what you want. So you want, in this case, in the request relief and judgment against the counter defendants as follows. Counter plaintiff praise judgment against counter defense in each of them as follows. That's an error there. That paragraph got repeated twice. Shouldn't have. On all causes of action, want for general damages in the sum of $50,000 multiplied by the number of days in constructive and actual imprisonment. The loss of earnings according to proof, that the court enter a declaratory judgment that defendants have acted arbitrarily and capriciously, have abused their discretion, and have acted not in accordance with law but under color of law. This is a declaratory judgment. Declaratory judgment is where you're asking the court not for money, you just want the court to decide what the position of the parties is. Okay, so that's one of the things. That the court enter declaratory judgment that counter defendants have acted contrary to constitutional right, power, or privilege. That the court enter a declaratory judgment that counter defendants' actions were in excess of statutory jurisdiction, authority, and short of statutory right. That the court permanently enjoin counter defendants from interfering in any way with counter plaintiffs' lawful right to negotiate and enter into contracts. That the court enter a declaratory judgment that the records of the court not of record are impeached for want of jurisdiction in the court, or, see, we sued the court too. So we want them enjoined and stated those records are wrong. For collusion between the parties and for fraud in the parties offering the record in respect to the proceedings, because there was some fraud involved. That the court grant counter plaintiff his attorney's fees. That the court grant counter plaintiff for such other and further relief as the court deems proper. And that paragraph, although it in one sense it opens the way for the court to grant more than what you asked for if the court decides that's proper. But the fact of the matter is that you don't need that paragraph to get that benefit out of a court. Okay? However, the general rule of operation in practical terms is they won't give it to you if you didn't ask for it.
So
Okay.
better put it in.
Yeah, but you're writing the lawsuit yourself, or you're writing the judgment yourself anyway, okay, for costs of suit. Costs of suit include filing fees, cost of service, that kind of stuff. That's what it means by cost of suit. Okay? So, that's that.
Now, attorney's fees is always a separate item, but since
Yeah,
we're
that's
not
separate from cost of
engaged
suit.
in that, suppose we hired someone to help us along the way, someone like you, how would we call
Well,
it?
you can collect attorney's fees even if you didn't have an attorney. Yeah, there's case law in that you can do that. But normally you cannot collect attorney's fees. The only time you collect attorney's fees is if, let's say, it's in your contract, where the parties agree in the contract that the loser pays all the attorney's fees. That's one condition. Another condition is if statutorily they say that in such and such a case, like civil rights suits, a lot of times you'll see it's written right into the codes that you get attorney's fees too. But you have to have that special provision. Otherwise, you're on your own with attorney's fees.
Right, our dealings with the IRS, we're not going to get.
Yeah, well, you might make a civil rights case out of it. I don't know. Anyway, law of the case. You remember we said attachment G? So here we have the law of the case. The law of the case is decreed as follows. Now remember, we incorporated all of this by reference as though fully stated herein. So that's the key phraseology. And then we started quoting from things. It is the public policy of this state that public agencies exist to aid the conduct of the people's business, blah, blah, blah. California Government Code, section 11120. Now, you remember I told you that statutes and codes do not apply. Okay? We are going according to common law. The common law says that if you suffer an injury, you're entitled to compensation. And if that person has an obligation, he must fulfill that obligation or pay the damages or pay the injuries caused to you. That person that you're suing is probably a citizen of the United States or a citizen of the state. If he is, he's subject to the codes, isn't he? That's his obligation. So I would use the code that he is obligated to for his failure to obey his obligation. Not my obligation. Doesn't apply to me, but it applies to him. Okay?
Now, in all of this discussion, Bill, you're talking about a California court. If this is a
Any
tax
court, any
not a
state.
tax court, right?
Well, it's any court, any state. You know, you have a set of rules that they operate by, or the citizens operate by, or whatever it is. You have to search them out and apply them.
What I'm asking is,
Mhm.
if the first, I'm not sure what some of these people, like Lark and Rose, some of those people were, taken into some tax court on Terminal Island and.
I don't know.
That's not a court of record. That's-
Right. Unless it's a tax court, then it is a court of record.
Terminal Island, that's.
You remember I read that?
Right, you did say
Yeah.
Not the franchise tax board.
No.
Right.
Right. Franchise tax board, I would say that one's pretty easy because you do not yield your sovereignty to the agencies which serve you. If they can command you to do something, then you don't have any sovereignty. Right? So you assume it's your court, bring those rules in because those rules apply to them. They're dedicated. Those officers take an oath of office, or they should. They're mandated to take it by their constitution. So you hold them to their obligation. And their obligation is to leave the sovereigns alone. Okay?
Excuse me, Bill,
Mhm.
but the franchise tax board is poised and ready to grab my bank account.
Sure.
And they say that in a threatening, demanding letter.
Well, of course, you gave them every indication you're a citizen, probably.
No, I did not.
Okay.
I denied everything.
Did you sue them?
In past
Did
letters
you sue them?
up to my eyebrows.
Did you sue them?
Then I sued them.
Did you sue them?
Did I?
Yes.
Not yet.
Well, there's the problem. You can't defend against these things. You have to attack.
Okay.
Counterclaim.
In other words, I have to expend all my time.
Yes.
Preparing a lawsuit.
Yes, freedom's not
against-
free.
These people have no jurisdiction. over
Mary, freedom is not free.
me. I know that.
Okay, well, that's the price you have to pay.
This is your tool of offense to go after them.
Absolutely. Do a counterclaim on them, or if they're bugging you and they haven't sued you yet, do an original claim. But go after them for everything that's causing you a problem. See, otherwise they're just rolling on. They know they're not worried about you. Holler all you want. That doesn't mean anything. You've got to actually pull them into court.
What you need to do, though, is get their name and employee ID number.
And if you can't get it, you get their boss. And if you can't get that, you get the top manager. Somebody's got a name.
I'm in the process of getting the name, badge number,
That's what you need.
title.
Yeah, but you don't have to have it. You understand that? You go after whoever's. You go after the lowest name you can find that's above whoever you're looking for. And if he won't tell you who they are, you sue him because now he's part of the problem.
I'll give you the executive director's name.
Sure.
Okay. You know what? Isn't it, it's on the internet somewhere.
Okay.
No? Oh, okay. I'll take that.
The name will be on the website.
Okay, so what we do here is we quote these laws or we quote these codes that they are obligated to. Now, what's interesting about this is that here we cite where we got it from.
Okay.
Remember this, the words come from the codes. The authority comes from the sovereign.
Okay.
Okay? So when the law of the case is decreed as follows, and you decree these laws and you show the references where you got the wording from. California Government Code section 54950, okay, or whatever it is. So you put that in there. The attorneys come along, they think you're working with code law. No, you're in common law,
Incorporating.
and you're injured because they didn't follow their obligation. You see that? You're not bringing in the power of the state. You're bringing in your own power of you, the sovereign. You decree the law, subjecting to the law, but they are citizens. They had a predetermined obligation to follow these rules anyway. Okay?
You just remind them of it.
Yeah, in a sense, but you're laying it out here. And so here's a whole bunch of stuff. We got 6 pages of rules that apply to them in this particular case. We also define what a court of record is. Here's a court of record, and here's the here are the prior case law that applies these things. See, I told you everything I put in here is backed up one way or another. So a court of record, going up here. To be a court of record, a court must have 4 characteristics and may have a 5th. They are A judicial tribunal having attributes and exercising functions independently of the person of the magistrate designated generally to hold it. That's Jones versus Jones, 188, Missouri Appellate Court, 220. Then it's in Southwest. You got Ex parte Gladhill and so forth, see? Those are the cases that support that aspect of a court of record. And so we've got all 4 of them are well documented. Okay? The following persons are magistrate. And since this is a California orientation, we got California cases. So far, so good, right? Mm-hmm. So that's what you do to deal with them. But the beauty of it is, remember, somebody here forgot it just a few minutes ago. Remember, the tax court is a court of record. Why? Because the federal government voluntarily gave up their jurisdiction and said, this is what it's going to be. And we're committed to that. Okay? So what's a court of record? Proceeding according to the common law. Right? Magistrate can't make any decisions. Right? So it's really nice. People have been using this in the tax court. They've been going in there and they've been issuing orders, vacating the decisions. But remember, whenever you issue an order, be sure to put in all these things, the law of the case and so forth, because you need to educate these people. And don't take a shortcut. Every time you issue an order in your case, be sure to repeat all of that in each order. You don't want them to just see the order and not see the reasons that you're boss and they're not. Okay, so fortunately, if you're using a word processor and not using a typewriter, you just do cut and paste. Okay, just copy it over. It's real easy to do. If I'm particularly angry at somebody, I think they're really trouble. What I will do is and I have multiple, people that I'm suing or whatever, I will sometimes make copies and then I'll modify them slightly. So each one's really different. It forces them to read them all. Okay? I'll give you a good example. Habeas corpus can be filed in more than one court at the same time. Regular lawsuit can only be filed in one court at a time. But our habeas corpus can be filed in any. So one case we did, it was a particularly serious problem with this judge. And so we filed a habeas corpus in every possible court that might have jurisdiction. This was this occurred in the United States District Court. So we filed a habeas corpus at the United States District Court level, the appellate court level, the Supreme Court level, the state Superior Court, the state appellate court, and the state Supreme Court. So that was 6 courts right there. All on the same day. Each habeas corpus was slightly different, just to make them work. Okay? These guys, they wanted to play dirty pool. All right, we'll play dirty pool too. But in an honorable way. There are legitimate changes done by choice. Okay? So, your lawsuit is going to be just like a normal lawsuit, remember, except the first line has that special wording, and you have the decree where you decree the law. Other than that, they're the same as a regular lawsuit.
Action at law.
It's an action at law. Thank you. Thank you. I stand corrected. I got to be careful how I talk now. So, on this website, we have elements. Let's see if I got it here. I don't see it. Court papers, okay? Court papers are letters to the court in a special court format. Okay? In an action, here we go. A motion. Look at the motion part. A motion to the court to do something could consist of the following: a notice of motion, the actual motion, the notice of motion, that's a one-pager. almost a one-liner. Okay, you're just giving them notice you're making a motion. Then the actual motion itself, that's usually 1 or 2 lines. And then you have the law of the case and you have the facts. That's the affidavit part. Okay? You put in the law of the case, and then you have a brief. Now the brief, also called points and authorities. In California they say points and authorities, in other states they say briefs. But basically, what a brief does is it brings the whole picture together. So a brief states what the law is, states what the facts are, but not as an affidavit. It states it as a pulling from your affidavit, okay? And it paints the picture. This is your argument, your court argument. You say what is, and then you have to serve people with it, so you serve them. And you have to inform the court that they've been served, and that's what a proof of service is. Proof of service is merely a statement saying everybody got a copy. Okay? And then finally, you might have a proposed order. Now, here's an interesting fact. Attorneys are not allowed to present proposed orders. But you in your sovereign capacity, you can. See, an attorney cannot present a proposed order, but you can. Now, what happens, you go to court, if the judge makes the decision, the judge will then instruct the winning side to write up the order. That's okay. But when making the initial motion, they're not allowed to put a proposed order in. That's in the rules. Now, a lot of them violate it and do it anyway. You know how that works. But basically, that's it.
On proofs of service, do you use the marshals, or do you find it effective just doing proof of service by mailing?
Whatever way you can. Well, I see what you're saying. Well, I've never been clear on this mailing thing, okay? I know that if there's some difficulty in serving, sometimes you can serve by mail. But the bottom line is they prefer that you either serve them directly or do what's called a substitution of service. In other words, you couldn't find them to serve them directly, so you deliver something to whoever opens the door at the home or a business office, and then you mail a second copy to the same address. And that two-pronged service substitutes for the single-pronged service of giving it to them directly. If you look in the procedures, the legal codes on how to serve, you'll find there's a half dozen different ways to do it. If you know the person's hiding in there, never answers the door, but you know he's there, go back to the court, tell the court what your efforts were to try and serve this person, and let the court know that somebody's hiding there, and ask for an order allowing the sheriff to force his way in and serve the person. Okay? That's another technique. If you can't find the person, you can serve him by publication. And some jurisdictions require that you ask the court permission to file by publications. Others say you can do it automatically. Okay? And then finally, if you can't find the person anywhere, you can serve the Secretary of State. And it's his problem to find the person and get the papers to him.
Just do MS.
So there's lots of different methods. You cannot hide from court procedure. That stuff of hiding from service doesn't really work if the person knows.
Might give you a little bit extra time, but that's about all.
Yeah, you take longer, but they can't hide from service, because if nothing else, you serve by these alternative methods, and then even if they never heard of you, they default.
How do you serve a judge?
Same way you serve everybody else. You might use the marshal, that make it a little easier. But I've served judges simply by going into the courtroom and handing the paper to the gatekeeper. Who's that? That's the marshal right there at the court. Okay, because court's in session, I'm not going to interrupt the judge. And I say, I have these papers to serve to him, and here they are. And then he might try to turn them down. We've had him actually force them. Yeah, this guy got
The
rid.
papers,
Yeah.
Shut up.
No,
My face.
he's got it. You know, when you give it to him, that's gone. You haven't. He can stuff them all you want. You can walk off with them in your pocket, but you didn't put them there.
I just went downstairs and there is someone, I just go, listen.
Well,
there's
yeah,
someone
that's-
here
yeah,
that
plan B.
will accept
Plan
service
B.
For the judges.
Yeah.
Took 20 minutes for the guy
Yeah.
to come down. but
And
that's what
sometimes,
I did.
yeah, sometimes they have special personnel designated to receive service. If somebody,
Yeah.
if I run into a snag, I don't get hard boiled the first time around. I say, okay, well, how should I serve this? I'll ask the person, do you have a procedure for it, and so forth, you know? And usually there is, so it's not like it's a problem. A lot of problems are created by us ourselves, you know, just by being, you know, too pushy or something. When a simple
Right on
little,
the dot.
yeah, when a simple polite question, they might just say, okay, here's where you go to do that. You say thanks, you know. So there you are. I guess it's time to quit. It's 9:06.
Good night.
And we covered it all.
Time for a nightcap.
Oh, by the way,
Yeah.
you're gonna have a real problem unless you
Got who?
learn to read hieroglyphics.
You got extra
People
like
say
this?
they're not writing in hieroglyphics.
Over there, stacked over there somewhere. He does an extra.
Then read me your goddamn automobile contract and tell me what it says.
We're gonna leave that song one more time.
Movie-wise,
Good night, we love.
are you thinking, the right thing? You gotta get that from the science history
Thank you,
channel.
Mr. Brown. I
You're
need to
welcome.
return that to Richard, the book.
And the
So
product,
what,
There you are.
we'll go buy it? No.
It has the publisher in there.
I know.
Just call the phone number. It's an 800 number.
Yeah, but I mean, how's the
See?
book? How's the book?
I don't know. I didn't look at it. I've been busy.
you just have to look at